Understanding New York's VTL Section 1193, the prompt suspension law and pre-trial license consequences. Being arrested for driving while intoxicated in New York can cost you your license before any trial begins. The prompt suspension law lets judges take your license at the first court appearance. Many drivers expect only future fines and dates, so this immediate loss is a shock. Acting quickly and understanding your rights can mean the difference between limited driving privileges and total suspension. The Kugel Law Firm stresses that a prompt response is critical because its legal team has helped many people keep their driving rights. Under the prompt suspension law, courts must suspend your license when you are charged with a serious DWI and prosecutors show a chemical test at or above the legal limit. Less serious impaired driving charges are excluded. Once these elements are met, the judge issues an order and your license is taken away until the case is resolved. You can ask for a brief Pringle hearing before the order is signed. This hearing lets a DWI attorney challenge whether the prosecution has enough evidence to suspend your license, though the bar is low. Refusing a breath or blood test does not help you avoid suspension. The prompt suspension law does not apply without a test, but a refusal triggers a separate DMV proceeding that can lead to a longer revocation. If your license is suspended, you can seek a hardship privilege at arraignment. To qualify, you must show that without a car you cannot reach vital destinations like work, school, or medical care. Public transportation being inconvenient is not enough. If the judge is convinced, you will receive a restricted license allowing driving only for these essential purposes. The privilege is unavailable if you refused the test or have a recent DWI conviction. Because refusal cuts off this relief and causes an additional revocation, it can double the penalties. A DWI arrest opens two cases. In criminal court, the prompt suspension is immediate, and later penalties may include fines, probation, and a conviction-based revocation. At the DMV, a refusal hearing looks at whether police had grounds to believe you were impaired, whether your arrest was lawful, and whether you were warned that refusal would cause suspension. If the administrative judge finds those elements, your license will be revoked for at least a year. Because the court and DMV are separate, a not guilty verdict does not protect your license at the DMV. Penalties can also stack, leaving you without driving privileges for more than a year. If you took the test, a hardship privilege covers only the first month of suspension. After that, you may apply for a conditional license that allows limited driving for work, school, and necessary appointments. This option is not available if you refused the test or have a recent DWI conviction. Refusal blocks all pre-conviction driving for a year, even while your case is pending. A DWI arrest in New York triggers complicated criminal and administrative processes that can quickly remove your ability to drive. The prompt suspension law, hardship privilege, and conditional license make early decisions crucial. Consulting an attorney right away helps protect your license and navigate these rules. The Kugel Law Firm's DWI lawyers understand both the court process and the DMV system and have helped clients reduce the impact of an arrest. If your license has been suspended or you face a pending DUI charge, call the Kugel Law Firm at 212-372-7218. The firm is at 111 E 125th Street 2nd FL, New York, New York, 10035. Early legal advice can preserve driving privileges and improve your outcome, so do not delay in seeking help from a lawyer.